Hello, everyone. My name is Victor Voproskis, and today we're going to be talking about succession planning for those that may own cottages or cabins or maybe even recreational land. And we're also going to discuss some of the problems that are associated with owning these and passing those assets on to the next generation. And then at the end, we're going to present solutions on how to resolve those issues we're going to discuss. So with that, well, let's go ahead and get started today. First, let me introduce myself. As I mentioned, my name is Victor Voproskis. I'm actually one of the shareholders or owners of Access Estate Planning. You can see my credentials up there. I'm on my 20th year of practicing law. And I'm also a financial advisor in addition to being an attorney for 20 years. And in our firm, we actually approach, estate planning a little bit differently than most law firms. You see, on one hand, there are firms that just have estate planning practices, and then there are also other firms that may just have financial advisory services. And we are sort of in the middle. We're combined. So we actually have an estate planning practice. And as I mentioned, I'm a financial advisor as well with Abundance Financial Coaching. And so therefore, we are able to address the entire estate. In other words, there's no reason to have an estate plan if you don't have an estate, correct? So we found that for most of our clients, I would say that meshing of together financial and estate plans work well. We do have clients that we just do their estate plans. And then we also have clients that we just do their financial advisory services. And then, of course, we do both for majority of our clients. And any of those options are perfectly okay with us. Now, let me share a little bit of information about Access Estate Planning. Access Estate Plans Division Lambert Lesser, which was founded back in the 1920s, so we have been around a long time. Access Estate Planning is solely focused on estate planning matters. That might include not only just estate plans, but power of attorneys, administration, estate administration, such as for with trust, or maybe a probate if someone just had a will. And we're very big in giving back to our community. So a portion of every estate plan we do, we actually donate that back to charity, and we let our clients choose that charity from a list that we have vetted. And then, of course, we always support our active first responders and military. That is both close to my heart, as my brother's a first responder, as well as my sister. And so that's very close and dear to my heart as well. Something else at Access Estate Planning that sort of sets us apart from other law firms is we are a member of the American Academy of Estate Planning Attorneys. Now, this is a great honor for us and a great resource for us and our clients. And first of all, we are actually only one of two law firms in the state of Michigan that's actually able to be part of the American Academy. The great thing about the American Academy is, one, your firm's got to be solely focused on estate planning. The other thing is they require each attorney to have 36 hours of continuing education in estate planning and tax laws every year. So it's an ongoing. And then finally, we have members throughout the country that we can reach out to. So if we have an issue with a particular, maybe it's a national bank, we can reach out to our members. Hey, does anyone have a contact in this bank that could help us? And inevitably there is. And so it is a great resource for us. So what are our goals for today? Well, one of the things we want to do is I'm going to show you that anyone that's watching this, or anyone that knows someone that has a cabin or a cottage or a recreational piece of property, they do have a problem with inside of their estate. They just don't know it yet. So what we're going to do is discuss some of the wrong ways to leave this asset to the next generation, your children. We're going to also show you how do we keep it in a family, and even some ways to protect it from creditors and maybe even divorces. So first of all, why is having a cottage or recreational land a problem to begin with, right? Well, first of all, we typically have multiple owners when we pass it on to the next generation. And when we have multiple owners, that means multiple disagreements. Rarely will everyone get along every single moment of every day. And we all know that our children are all different. We have different ages, they have different goals, ambitions, and they have their own families on top of it as well. So we always have to ask ourselves, and you can see the question at the bottom of this slide, what would really happen to your family if you didn't make it home tonight? And I always like to start off any of my educational seminars, webinars, by asking that question, because sometimes I think we really want to avoid asking that question of ourselves. What happens if I wouldn't make it home today? What happened if something happened to me before I woke up tomorrow morning? And so that's a big issue. And we want it to be something that everyone addresses for themselves. So with that, let's go ahead and give you some good news now that we gave you some sobering news. First of all, owning a cottage or recreational land doesn't have to be a problem. We just have to address it early on. And actually, if we prepare the correct solution, we're going to actually bring the family together and strengthen the relationships of our children and our generations that follow. All right. But the thing is, we have to actually take some action now. And we all know what procrastination is, and that's delaying, putting something off until tomorrow that should be done today. The problem is tomorrow never comes, right? So what we're going to do is we're going to give you some of that knowledge, show you that the different issues that you're going to face, ways to address it. And then hopefully we'll be able to get you to take some action by the end of this educational webinar. So first of all, let's frame the issue. What are we trying to actually accomplish through estate planning in general, right? And it doesn't matter if you have a small estate or a very large estate. The issues are still the same for each of those families. Well, we want to avoid probate. Why would we want to have any courts or governments unnecessarily interfering with our hard-earned wealth? We want to avoid any unnecessary taxes and fees. That would seem to make sense. And we want to be able to pass and protect our assets down to our children, our next generation. Maybe it's even a charity. We want to plan for incapacity. So most people think of estate planning as when you pass away. But the fact is, there might be actually a greater chance that you will become disabled or incapacitated before you pass away. And a well-drafted estate plan can address those issues while you're alive as well. And again, we want to make sure we don't have a tax issue. And we want to preserve your legacy. We don't want to be just some name on a family tree. So cabin fever. And for those of us that are watching this in Michigan or in the northern states that have winter, currently this is being recorded in February, and we've had a lot of snow lately, and it's cold. And most of us are probably having cabin fever. It probably also doesn't help the matter that we're dealing with a global pandemic. Some of us are still locked down, not able to go into work. And so we're getting that cabin fever. But actually, a cabin fever I want to talk about is a little different. So what is cabin fever in the context of this situation that we're discussing today, cottage succession planning? And that is the disease that families are bound to have when a cottage is part of your estate, okay? So I'm going to actually give you an example of what a cabin fever actually is and the symptoms. And then we're going to discuss how we treat it. So I'm going to introduce to you the Getalong family. You see, mom and dad Getalong are retired, and they have 3 children. The oldest child is Joe, he's the fisherman. Then we have Pete, he's the middle son, he's the CPA. And then we have the sweetie of the family, and that's Sally, okay? Let's talk for a moment about mom and dad Getalong's estate. And this we see more and more often when we're talking about cottages in northern, at least Michigan. So mom and dad were married in 1960. Dad worked for the auto company. Mom was a teacher. And they bought a house in the Troy, Michigan area for $25,000 back in the mid 1960s. But today it's worth nearly $400,000. Around that same time, though, in the 70s, they bought a house up in Grand Traverse County on a lake. But today, that house is worth almost $600,000. Now, both mom and dad are retired. They have about a $500,000 nest egg. Of course, they get their pensions and Social Security, but they really love spending time with their grandchildren. Well, let's start framing the issues that are going to occur with the children and this cabin up north on the lake. So remember, the oldest son, Joe, he's married. As I mentioned, he's the fisherman. Now, he also loves to party, and he has some job issues. He struggles with employment. The CPA, Pete, he's married, loves spending time with his family. Problem there is his wife's a little bit controlling, at least as to how mom and dad perceive it. And he's not the partier of the family. He leaves that to Joe. And you see Sally, she's recently married. But the problem is she lives in Atlanta, Georgia. She doesn't even live in the state of Michigan anymore. And her marriage is shaky due to some gambling issues that she has. So as you can imagine, tragedy strikes the family and mom and dad pass away. Now, their estate plan was a traditional estate plan that simply just said, we're going to, marshal all of our assets. That means gather all of our assets, simply divide it 3 ways equally, and dump it out to the kids. So it's outright and equal shares. Well, when that happens, in particular just to the cottage, that means that each of the 3 children own the cottage as 1/3 owners and tenants in common. And there are some real problems when you have a piece of land that you own with someone else's tenants in common, and we're going to go through those in a moment. So you might ask, well, why go through the probate process and leave the kids outright this as tenants in common? Why? I can avoid probate. I'll just add the kids right now on the cottage. Well, first of all, if you add the kids' names right now to mom and dad, if mom and dad get along, or to name the kids on the deed right now before they passed away, we have several issues. One, it exposes every one of them all to creditors of each other's. That's not a good situation. And we also have a huge tax basis issue. You see, what will end up happening is when you add the children on, they're going to receive that $60,000 tax basis. So if they were to ever sell it for $600,000, they're going to incur capital gains taxes on that difference. So that's not something we'd want to have happen. Now let's talk about tenants in common and the other issues with tenants in common. You see, first of all, any one of the 3 children has a right as a tenants in common owner to partition. That means they can force the court to sell the property and divide up the money, because you simply cannot divide a cottage into 3 parts and cut it up. So instead, the court would sell the piece of property, take the money, and divide it 3 ways. So we each own an undivided interest. Okay, that means that Sally, for example, could transfer her 1/3 interest or sell it to anyone that she wants, whenever she wants. And let's say Pete, the partier, Pete's accountant. Pete goes up and uses the cabin all the time. He doesn't have to pay rent to Joe, the fisherman, or Sally, the sweetie. He can use the cabin and not have to worry about it. Now, this could be scary. So Joe, the fisherman who has troubles with his employment, may need some income. He could actually rent out the cabin to some stranger, collect the rent, and there's nothing that Pete and Sally really can do about it. Now, who's going to take care of the cabin? Well, there's no requirement to reimburse someone for taking care of it, maintaining it, servicing it. So basically, at the end of the day, you have limited obligations to the other owners who have ownership as tenants in common. So we know that we're going to have a problem, but who really is the bad guy here? Right? What went wrong? With a little bit of planning, we could have addressed the issues that this family were going to face, because the fact is the children never had a chance by simply just taking the cottage and distributing it outright as tenants in common to these three children, especially given the circumstances of this family when they were all different. And here are the issues they faced. They faced the issues of use. Now, the fact of the matter is, Joe the fisherman liked to use the cabin and used it more often than anybody. And when he was up there, he partied pretty good. Well, that kept Pete the accountant away because he didn't like that party lifestyle. He didn't want to expose his kids to that type of behavior. And Sally, she just simply lived out of state. She just really wasn't getting to northern Michigan very often to use the cabin. So then that brings in the issue of equity, right? Why should Sally pay some of the taxes and expenses, her 1/3 share, when she's really not using it all that much? As tenants in common, there are absolutely no buyout provisions. So if Sally says, listen, I'm in Atlanta, I'm not using it very often, the cabin, I would like to just sell my share. There's no provision that she can rely upon to force her two other brothers to purchase her out. And there's no way for the brothers to stop her from selling it to some other third party. And what happens if Pete, remember he has the controlling wife, what happens if he gets a divorce? Or what if Sally gets a divorce? Maybe the spouse will end up with half of the third ownership in the cottage. That'll be for some unpleasant stays at the cabin with the family. So now let's talk a little bit about how this story could have ended had we did a little different succession planning. And that's why you're tuning into the webinar, to find out, well, how do I address this issue? Now that we've set up the issue, you understand the issue, how do we address it? And that is basically through a cottage trust. You see, if we don't manage this disease, this cabin fever, it'll lead to lawsuits. And if you're hearing the word lawsuits, you should have dollar signs going off in your eyes, because you know that attorneys are going to be involved. As I just mentioned, we have the issue of you may have third-party new owners that aren't even family members. And the reality is, we're really talking about some serious money here. This cabin, for example, is $600,000. And prices these days have just seemed to go up and up and up, especially when you have a cottage on a lake or some type of waterfront, or if you have recreational land that has some acreage. We know, I can tell you over 20 years, that there's always going to be some type of injustice that somebody's going to feel. One of the three kids or one of the two kids, someone's always going to feel that they're being treated differently. They don't get to use it. They're paying too much. They're the ones having to take care of the cabin more so than anybody else. And eventually someone's going to want to sell the property and force the other two to buy them out. And if they can't, then the court could potentially sell it to a third party and the other two lose out. Or the person could just sell it to a third party and now they just became partners in a cottage with someone they didn't even know. So I will tell you that the estate planning community really does owe all of you an apology. And that's because of traditional estate planning. You see, traditional estate planning typically looks at assets as simply trying to divide it, dump it, and then unfortunately the assets are dissipated. See, traditional estate planning wants to focus just on avoiding probate and taxes. But traditional estate planning doesn't deal with the real issues that a family will face in estate planning, especially. It doesn't look to what the goals and objectives are, the different family dynamics, and how to make sure that we're meeting the goals of protecting the legacy of mom and dad, and making sure we're passing that legacy on and protecting the asset at the same time, and strengthening the relationships of the children. That's truly what mom and dad want. They don't want their family to be torn apart by their passing. They want their passing to be a catalyst to bring the family together. So in defense of lawyers, cabins truly have been an issue, right? Everyone's always owned cabins, it's always been part of an estate. But see, lately, I would say within the last 15 years, cabins are starting to become very valuable. Sometimes they're the largest piece or largest asset in somebody's estate. And so now it is becoming a larger and larger problem that we need to address in an estate plan. So what are our different options? Well, basically, a cottage owner only has 4 options. You could sell the cottage before you pass away. That's 1. 2, you could add your kids to the title during your lifetime. And we talked about why that's bad from a tax standpoint, a creditor standpoint. You can leave the cottage outright to the kids as tenants in common. That's what the Getalong family did. That's the 3rd option. And that's bad for all the reasons we just been discussing. And then the 4th option actually is to do additional planning, and that is to have a cottage trust or a family limited liability company. So let's first talk about the pros and cons and look at the difference. So the cottage trust, first of all, we want to make sure it's going to depend on whether or not your house is qualifying or your cottage is a principal residence. So we're going to have to address that issue. Okay. With a trust, you are not going to have any liability protection unless the trust is irrevocable. Now, revocable trusts do allow the client, mom and dad, to maintain control during their lifetimes. But once the rules are set in place, mom and dad pass away, the rules are very hard to change. Now, the good news with a trust is there's no uncapping of the property taxes. If you're leaving it to a child, a grandchild, sibling, parent, and mom and dad are able to fund the trust for operating or maintaining the cabin or cottage. Now let's talk a little bit about the LLC, the limited liability company. Well, the great thing is it provides liability protection for the owners. So that is a plus. And it gives you the ability, mom and dad, the ability to make gifts during their lifetime to the children or the beneficiaries or whomever they want to inherit the cottage. And also at that same time, they're able to, when they gift that each year, they're able to take that asset and remove it out of their estate. Now, the one thing we have to be careful of as we're transferring ownership in an LLC, it may and likely cause an uncapping event. But another pro for an LLC versus a con is it's flexible. So it normally is governed by what we call an operating agreement. That's where all the rules are as to how we're going to manage the cottage. And the members or owners of that cottage, of that LLC, can change those rules and adapt as circumstances change throughout, the generations. With a trust, as I mentioned above, that's harder to do because once mom and dad pass away, those rules are going to become a little more steadfast and irrevocable. So one of the things that we sometimes address with our clients is a hybrid model where actually the property is owned by the LLC. So we have some liability protection, but the trust is the sole owner. And then we have an operating agreement. So that way we get the best sometimes of both worlds. Other times we see where mom and dad will sometimes say, well, we want it in a irrevocable trust while we're alive, so we have control. And then we actually state right in the trust that upon their passing, it's to be transferred into an LLC. And then there's already an agreed upon operating agreement that goes into effect immediately. So those are some of the different ways using a cottage trust or a family limited liability company that we're able to protect the cottage and pass it on. So why would you choose us to help you with this? Well, first, as I mentioned, our experience. Again, I'm going in my 20th year. We're part of the American Academy of Estate Planning Attorneys, and I have a real passion for what I do. I had a good friend that went through this exact scenario that we're talking about. The house was in northern Michigan on a pretty exclusive lake. Parents had bought the cottage for about $40,000. At the time that the kids inherited it and all the issues that happened after a couple of years of their parents passing, it was worth about $850,000. The short story of the long version is that ultimately there was a disagreement between three of the children. One thought he was constantly taking care of everything. The other two were not. He was paying everything or constantly chasing them down for payments. And ultimately he wanted to be purchased out. The other two didn't want to buy him out and they didn't want to sell it. So he went to court and forced a sale. And then one of them ultimately bought the other two out. So one sibling bought the other two siblings out. And unfortunately, a few years later, in the downturn back in 2008, she had to file bankruptcy and the family ultimately lost the cottage. So that's a very unfortunate event. I've seen it also even in my own family. When my dad passed away, my dad was 47, and how that affected the family and some hunting property that we owned, and the difference in how that really caused some issues between the family members. We also charge a flat fee. We do not bill by the hour. You will not see us charge for phone calls, copy costs, recording of deed fees, charges. We just simply don't do that. After we have a consultation with our clients, we know what the circumstances are, what is going to be needed for that estate plan. We provide a flat fee. So it's very clear when our clients leave the room, or prospective clients leave the room with us, they know exactly how much it's going to cost, and that doesn't change. And we don't use cookie cutter documents. The fact is, every estate plan is tailored, or Cottage Trust LLC is tailored to that family. You see, every family is different. Every family has different goals and circumstances and different family dynamics. And so we want to make sure that we're capturing that. And anyone who, any client that starts with us with an estate plan, whether it be a cottage trust or a regular trust, is automatically enrolled in our maintenance program for 1 year, which means you have unlimited amendments for that entire year. So we can constantly change it if something changes or you changed your mind. So we want to offer anyone who's watching this video an educational credit. So normally for a consultation, we would charge $350, but for those of you watching this webinar, just mention you watched this webinar and the consultation is free. No obligation. You just set a time either in person or by Zoom, and we will meet with you. I will talk with you. We'll see how I make sure I can answer all of your questions. I'll have some questions for you, and then we'll figure the best plan or design going forward. I will give you a flat fee pricing at that time once I know what is entailed, and then we can decide whether to go forward or not. And those okay. That's perfectly okay for us. So what should you bring to that initial consultation or have available? Well, if you have a current estate plan, you'd want to bring those documents, a balance sheet of roughly what your assets are worth, and then of course any copies of deeds to your real estate, especially when we're dealing with a cottage or recreational land up north. And I want to thank everybody for listening to this webinar. Hopefully you found it informative. If you want to get in touch with us, there's my email, victor@accessattorneys.com, and our phone number, which is 248-251-1001. And again, thank you, and hopefully to see everyone soon.